Hello, friends and clients. I am Jennifer Walker Gates, board certified immigration attorney with JLW Immigration Law Group. And I am glad to be here today with you to talk about delays. This is something that is a pervasive, persistent, constant, never ending issue with the immigration system in the US because they take so long to do their work. Unless they're just trying to detain and deport somebody, that can happen really fast. But even that is slowing down as we see it happening to more and more people and things are getting more crowded. That's also slowing down, but so are processing times. So we're going to be talking today about delays. What is a delay? When do you know that a case is actually like there's an actual delay in the case that's a problem or that represents a problem, or if it's just normal? What to do depending on what kind of case you have. We will be talking today about how to deal with what feels like never-ending waiting. Before we get into all of that, please take a moment to share, subscribe, and comment. Join our YouTube channel, subscribe to our YouTube channel, like us on Facebook, follow us. We are here at least once a week to provide information and updates that are based on real experience with real cases, not rumors, not scary like clickbait. That is not what we're interested in. What we want is to make sure that people going through this process have information that they need to be successful. And so that is what we provide. If you or anyone that you know can use that kind of information, please share it with them. And if you want specific, personalized, confidential information, don't hesitate to reach out to us. Our contact information will be scrolling across the bottom of the screen this whole time. You can call our office or you can go to our website and click to schedule with me or any of the attorneys in our firm, and we will be honored to help you specifically with your case. When you post questions in here, I might not read it word for word. I might not say your whole name, just because we want to respect the privacy of individuals who are participating here today on our platforms. We want to make sure everyone is practicing good online hygiene and staying safe online. So I might not share your whole comment or your identity, but I do see your comments. I welcome them. And if you decide after the recording that you want to leave a comment, you may do that as well. We just ask that you be really careful with very private, personal information and don't post anything like that. Generalize your questions, make them sort of hypothetical, do whatever you need to do to make sure that you're protecting your case, your privacy, your personal information. All right. So that's all of my housekeeping. Let's talk about delays. We are starting to see processing times changing from and trending in a direction that we're not as happy with as where they had been going before. As we all know, during the pandemic, well, first of all, the pandemic began during the end of the last Trump administration. One of the phenomena that we see with this administration is that they like to slow down on legal immigration. We saw that during Trump's first term. We're seeing it again. Staffing levels go down. I know that when USCIS was called back to the office after several years, when this president took office in January, they were all told, you got to come back to the office. Many employees of USCIS had to leave their positions because they were not hired for an office job. They were hired as a remote employee, and they were doing a lot of the adjudications work, a lot of processing work of cases from remote locations, not in an office. This president got rid of all that and got rid of those positions. A lot of those people left and won't be coming back. And we while the reduction of the federal workforce that we saw at the beginning of the president's term doesn't affect USCIS as much because they're not paid by taxes, they're paid by fees. When we file filing fees, we are paying for their processing. And but a number of those folks were, even though they weren't fired under the Doge phenomenon, they were removed if they couldn't go into the office for work. Probably not likely to be rehired because of limited office space. So we're starting to see slowdowns. We're starting to see processing times slowing down on all kinds of different cases, from I-130s to even the consular processing, even the scheduling of consular appointments is beginning to slow down. We did see a reduction in force at the Department of State. So the effect of that is that we will begin to see, I think, slower processing times in a lot of different types of cases. Not all. We're still seeing certain case types getting approved really, turned around and approved really quickly. DACA is getting turned around and approved quickly. Certain work permits for asylum seekers, for example, are getting turned around and approved quickly. So hopefully that will continue, but definitely some delays are beginning to show up. So what do you do if your case is delayed? Let's say you have an I-130 that's outside processing times and you want it decided. What do you do? So there are a number of things that need to happen in order for you to have the ability to get to what really, really works, which is hiring a lawyer to file a federal lawsuit. We'll talk about federal lawsuits in this video. They are common in cases that are delayed beyond what is reasonable. The government has a responsibility under the law to perform their work in a reasonable time frame. That's what the law says. And so if they are publishing a processing time but taking much longer than that, you can argue pretty easily that's not reasonable. So, and a lot of courts agree, and a lot of courts will hold them to that obligation to do their work in a reasonable time, get it done. Now, that doesn't mean they're obliged to approve the case, just that they're obliged to make a decision. But before you can file a federal lawsuit, there's some other stuff that you need to do if your case is delayed before you get to the lawsuit phase. The reason you need to do that is because when you do get to that lawsuit phase, you need to be able to show a judge that you tried everything you could to get a response, to get things moving, to avoid going to court. That's important. Judges definitely want to see that. So, first thing to do, if your case is outside processing times, like well outside, and you can't see any reason for it, call USCIS. They have a 1-800 number. It's 1-800-375-5283. And I have that memorized after many years of calling it myself. If your case, if you have an online account associated with your application or petition, that's an even better way to submit an inquiry about the time frame for processing. Do it online if you can. If you don't have an online account and you can't get one, make a phone call. Doing it online is great because everything that's written is well recorded and well preserved. That is an easy way to demonstrate when exactly you made the inquiry, to whom, what the response was, how long it took them to respond, etc. If you're calling on the phone, it's going to be up to you to maintain those notes and those records yourself. Make sure you get the service item number that comes with your call and your inquiry and record it. And then give them some time to respond. Usually they respond even to phone calls now by email, but it can take 30, 60, 90 days. None of that is unreasonable in the immigration field. So it's important to give them some time to respond. And if the response either doesn't show up or isn't helpful, then you can move to the next step. In my experience, the best thing to do as a next step is to file a request for case assistance with the USCIS Ombudsman. That's such a weird word, ombudsman. I'll put it in the comments. USCIS Ombudsman. And then I will also ask my pal Jackie to put the link to their website in our chat. DHS Ombudsman. Let's see. So here's the thing about the Ombudsman. It is intended to be a resource for individuals who have a problem with their case that they can't resolve without help. It's supposed to be part of DHS, an office inside DHS that helps people outside who need help. And if you are having a difficulty and you can't get it resolved, they're supposed to help you do that. Now, part of Project 2025 was to get rid of the USCIS Ombudsman. We saw that happen earlier this year. The Trump administration eliminated the Ombudsman's office. However, they have brought it back because it is required by statute. Congress passed a law that says we need to have this agency with an office inside because it's a huge bureaucracy. They're dealing with billions of pieces of data every day. There's going to be issues sometimes. And so the Office of the Ombudsman exists to help deal with those issues. If you go to their website, you can click on a link that says submit a request for case assistance, and then it has you fill out a bunch of details and forms. That's step 2. If step 1, making the inquiry with USCIS, yields no results for you, then step 2 is filing a request for case assistance with the Ombudsman. Then wait again, give them some time. Let them have the opportunity to respond to you in a reasonable time frame. If they do not, which they might not, even under the best of circumstances, the Ombudsman's office has never been robustly funded and resourced. They've always needed probably more resources and time and money than they have. Now I have no idea if there's even one single full-time employee there, but that's where you would go if you are having a delay in your case that you can't get resolved. Finally, step 3 would be hire a lawyer to help you file a federal lawsuit. Again, under the law, the government has an obligation to perform their work in a reasonable amount of time. We've been able to successfully file lawsuits to get cases expedited for lots of our U visa applicants. We've probably done around 30 of those cases and helped a bunch of our clients who were way over time get a work permit within a more reasonable time frame. But we've also been able to do that in other types of cases. Naturalization cases, we've been able to do the same. Long pending asylum cases, we've been able to get appointments expedited. Again, it's really important to remember that filing the lawsuit doesn't mean you're going to win your immigration case. What it means is the government has a responsibility to go get the work done. A lot of times cases get delayed just because there's some internal disorganization. Maybe an officer misplaced the file. Maybe there is some mild complication with the case that caused an officer to want to set it aside and not deal with it. And so it just has been sitting on someone's desk or on a shelf unattended to for a while. That's very common. There are a number of reasons. Again, this is a huge bureaucracy dealing with so much information, so many processes that sometimes there's just a little breakdown. So the lawsuit can force the agency to get to work figuring out where the breakdown occurred and how to fix it. And that can be a very effective way of getting a case unstuck. It is not cheap, really, anywhere to file a federal lawsuit. There is a lot at stake for the attorney in doing that. We must make sure that the claim is meritorious, that if they choose to fight back on our assertion that it has not been a reasonable amount of time, we are ready to fight. We have to be ready to respond to their motion to dismiss the case, explain the law, why the law supports moving forward, support the judge in denying their motion to dismiss the case. There's a lot that goes into a federal lawsuit. However, if you are ready to move your case forward, that is a really effective remedy for doing so. Hopefully, it doesn't come to that, and people can get their cases, get their inquiries answered, get their case assistance through the ombudsman's office if that's what you request. Hopefully, you don't have to do that. But for those of you who do get very delayed and who do get very exhausted and frustrated because you can't really move your life forward while you're waiting on this case that's overdue, reach out to an attorney. You are welcome to contact our office. We are certified and admitted in federal court to practice before the Western District of Texas, the Northern District of Texas. I recently was admitted to the District of New Mexico. There are a number of ways that an attorney, even licensed in Texas, could file a lawsuit in another state if needed. So don't hesitate to reach out about unreasonable delays. The harder part is that a lot of the delays that we have to deal with in this context are not considered unreasonable because they're what everybody deals with. And so it can be very frustrating and difficult to wait on the immigration agencies to do their jobs. And unfortunately, it's just part of the experience. I am going to turn to questions. Before I do that, let me take another moment really quickly to invite you to share, subscribe, and comment. In addition, feel free to hop over to our website and join our newsletter. We send out a newsletter once a week to our mailing list with information that's actually more detailed and specific than what we are able to share on social media. So join our newsletters if you want the opportunity to get regular updates and specific information about case types in your inbox once a week. We would be happy to have you on our mailing list. With that, let me turn to some comments. Bart's, good to see ya. Let's see. I'm seeing a question here that says, oh, it's about RFEs. What's better for responding to an RFE after the interview, mailing or uploading or online or both? That is a great question. In my experience, when you go to an interview and then get a request for additional evidence, that document that is sent to you will have very specific instructions about where to send or provide the response. If the document allows you to submit the response through your online account, that is ultimately where everything's going to end up anyway. And what I have seen with our clients and our cases is that those online accounts are effective and efficient and typically work really well. So if you're able, per the instructions on that request for evidence, if you're allowed and invited to submit your request through your online account or your response through your online account, I would probably say that's a great way to do it. What's really, really important is to be very, very sure that your response has landed in the hands of the officer who has your file. So if it's not super clear from that document that they provided to you that you are allowed to provide your response through your online account, mail it, but don't just mail it. Make sure you keep a complete copy of everything you mail. Keep a copy of the mailing label. Use a mailing label that you can track. Track the delivery of the package to the office and name the officer on the package when you send it in. Make sure the officer that is handling your case is identified as the person that that package needs to be provided to, and keep a copy of that. We copy everything as lawyers. We're copying stuff constantly. We keep scans of everything. I know it probably drives our clients a little bit crazy when we say that this is really important, but trust me, if you get a denial later saying you didn't respond to the RFE, and this has happened plenty of times in our office, you don't want to be stuck without proof that you didn't respond. So having the copy of everything, the mailing label, the confirmation that that mailing label number was delivered to the address on the letter with these documents included, that's really, really important. So whichever way you do respond, it's just really important to make sure you maintain access to a complete copy of everything and that you're able to confirm that the officer on your case has received those documents that they requested. That's really important. So I hope that that's helped. That's a great question. Let's see. Next question. Can you explain the USCIS new policy on NTAs for people where you file a benefit but they don't have legal status? Will some or all be issued an NTA while their case is pending? Was this always the rule that a pending case doesn't forbid the agency from issuing an NTA? Okay, great questions. You're right. We did talk about this new policy a couple of weeks ago, and it is good to know that people are still learning about it, asking questions about it, understanding it. We are as well. It is true that the law has always allowed USCIS officers to issue a notice to appear. That's what NTA stands for, notice to appear, to any person who was technically removable from the United States. Anyone who is in the United States without current valid status with immigration is removable. Okay. The difference is that in the past, different administrations have either encouraged or discouraged placing people in removal proceedings by USCIS officers. We've seen some administrations in the past where USCIS was much more willing and much more eager to place people in removal proceedings. We've seen other administrations where their focus was much more on reviewing applications, approving benefits, and not placing people in removal proceedings. They left that part to ICE. Now, this administration is encouraging USCIS officers to use the notice to appear more often, to place people in removal proceedings more often. I really do not think, and it remains to be seen exactly how this will play out in practice. We do not know yet. However, it would be very surprising to me if USCIS officers did a lot of this because they are already swamped. They are already overworked. As I said, a bunch of people left the agency. That means those who remained have more work to do than they did before. We are seeing this in interviews at USCIS offices quite a bit. There are a lot of delays. People seem tired. They're expressing exhaustion. So doing an NTA, a notice to appear, to send someone to immigration court from USCIS is a lot of administrative work. And so that's just more work again on top of what they already have. For that reason, I do not think it will be a super common practice. I think it is much more of a risk when an individual has filed for immigration benefits and they are dealing with some criminal issues or complicated immigration history in their past. I still don't think it's likely to occur in cases involving humanitarian benefits such as VAWA, U-Visa, T-Visa, TPS, and even DACA. I do not think it's going to be a common practice in those types of cases, even under this administration, because that would contravene the purpose of the whole program. And it is going to be more common, I think, in certain offices with certain officers than with others. Okay, so it's going to vary depending on the leadership of the office where the benefit is submitted. depending on the individual officer, and then depending on the individual who's applying. That's my prediction. I think that's really always been true. I do think this administration publishes a lot of information that is really, really scary and discouraging uh, as a means of, again, slowing down the cases in the legal immigration pipeline. They have made really clear that they're really interested in reducing immigration overall, not just illegal immigration, as they call it. So we are seeing this as yet another mechanism by which they're going to try to slow down legal immigration in the United States. Is there any truth that USCIS is asking IRS for tax records to use as a basis to take citizenship from immigrants through civil cases for fraud? So I do know that Department of Homeland Security has been making a big effort to get IRS data from especially on immigrants in order to cross-check for deportation history, address history, and things like that. It is possible that USCIS is also attempting to get that data as part of the denaturalization push. However, again, denaturalization is another tool that the administration wants to use to try to discourage people from applying and basically punish people for immigrating and becoming US citizens. Nonetheless, the data is really clear that denaturalization is very rare. Denaturalization requires an enormous amount of government resources because the standard that must be proven in order to win a denaturalization case is very high. And so even if USCIS attempts to get taxpayer data and attempts to find people who committed fraud in the naturalization process, it remains to be seen how successful they will be at denaturalizing individuals. My prediction is that it will still be exceedingly rare. So I hope that that helps. It is discouraging, I know, but what I keep repeating to my clients and to all of you is this is not a time to give up on your immigration goals. This is a time to buckle down and make sure that you meet every requirement and you're able to prove that you meet every requirement. That is what this moment calls for. We will lose rights that we do not exercise. And so while the law continues to say you are eligible for naturalization if you meet these requirements, we need to be ready to apply and make sure we demonstrate that we meet those requirements. Because if everybody just backs off, it's going to be all the easier for them to make changes to the fundamentals of those laws. So we have to keep pushing forward, exercising our rights, exercising our right to benefits under the law as it is written currently, and embracing our country as an opportunity for improvement, for being more generous, more fair, more just. That is what we need to be doing. All right. Bart says, is writing an inquiry about a pending application and mailing it to the field officer okay? Okay, so that's a great question. That might not be, it might not be a bad or harmful thing to do. I can't, as long as the letter is polite and respectful and professional, I think that it could potentially help. However, it's not one of the sort of prescribed methods for inquiring about the status of a case. Those include making the inquiry through the online account, making a phone call, or filing a request with the ombudsman. Now, the phone call, I will say this. This is really important. When you call that 1-800 number, 1-800-375-5283, there's an automated system that's going to want to keep you in a loop in the automated system of just like checking the case status, and it's going to be the same as what is shown online. It's not going to help you at all. You will stay stuck in that loop unless you say the word InfoPass when it's asking you what you're calling about. InfoPass is a type of appointment that you can get to go to USCIS to get assistance with certain things. Those include things like I-551 stamps in your passport, replacement I-94 documents, things like that. It is not really, the InfoPass processes aren't really available for individuals who just have a delayed case, although you might be able to get them to give you an appointment like that for a case that's really severely delayed. But the thing about saying the word InfoPass is that it will move you to a human being. It will get you out of that loop. When you talk to the human being, that human being can nudge the officer to give you an update or move the case forward or provide a case status update through their email. That's the purpose of getting to a human being in that system. And to do that, you need to say the magic word, and that is InfoPass. I'll write it in the comments. InfoPass. Now, if you do send a letter to the officer that you know has your case, again, I recommend tracking, making sure you keep the label number, track the label, track the delivery. It could be another piece of evidence if you do end up having to file a federal lawsuit, that you made a very good faith effort to try to move the case forward. In some cases, it might be effective. I would not put a lot of faith or stock in the idea that method would produce great results in most cases. So I hope that that's been helpful. I hope this whole call has been helpful. I appreciate y'all being here, coming to ask questions, to learn about the system and what's happening right now. I want you to know that I'm grateful that you're in the United States, that you've chosen to immigrate to the US to bring your skills, your talent, your devotion, your self-sacrifice, your hard work. Thank you. Please take good care, be safe. Please contact us directly if we can help you with your case. Call us at 512-633-1785. We'll be happy to schedule an appointment for you with me or with any of the attorneys in our firm. And you can also do that on our website directly. So with that, I am going to log off. Please take good care. We are here this week on a Thursday, which is a little weird. We're usually here on Wednesdays. Next week, we'll be back on Wednesday at noon right here. Please join us and we'll see you then. Take care.